Only 42% of Americans do this work. And from my experience, the vast majority of those don't get good tax advice. That 42% includes all the people who go online and do their own will, or go to Costco and buy the will software, or sign up with Susie Orman.
There's no need for the credit shelter trust.
So her question is, if you're using a living trust for your basic estate planning, you don't need the credit shelter trust. The answer is wrong again. Two different pieces, two very different pieces. The living trust is designed to avoid the probate. The credit shelter trust that would sit inside of that is all about the taxes. Now, the credit shelter trust is something that you shouldn't be afraid of either. It's a trust, set of instructions, just like the will, that appoints somebody, just like the will, only this time we call him the trustee. It's a set of instructions that appoints the trustee and tells the trustee what to do with what we put in it. Typically, the trustee of that credit shelter trust is the surviving spouse. Typically, the instructions are going to say, pay yourself whatever income is earned by whatever assets we put in there, and give yourself access to the principal if you need it. So most married couples start with the premise that when I die, I want everything to go to my spouse. Even if we do this tax planning, it still accomplishes that goal. But it needs to sit inside the living trust or inside the will. Okay?
So which is better, a will or a living trust?
So her question was, which is better, a will or a living trust? And the answer is, what I was taught as I went through school, all the way through elementary school and middle school and high school, we were taught that if you don't know the answer to a question, you say, I don't know. But then I went to law school. And law school, they teach you, a lawyer never says, I don't know. The lawyer says, well, it depends. And the answer to your question is, it depends. It depends on the circumstances. It depends on what you're trying to accomplish. As I said earlier, some years ago, I would have unequivocally said the living trust is the better tool. With the changes in the law that have occurred in Washington, for people who own everything in Washington, a will is a really good and safe tool to use. Is less expensive than using the living trust, and the biggest problem I see with living trusts is that people get all enthused about them in the beginning, and they're cool, and typically you end up with lots of documents in a really cool binder that you can put on your shelf, and you know you've done all your estate planning work and it's good. But then you go and you buy another piece of property. You sell the house, but you buy another one, but you don't remember to buy it in the name of the trust. Or you start that new investment account, but you forget to tell the investment people that you've got this living trust that it should belong to. So now we end up with some assets in the trust and some assets not in the trust. And when we have assets not in the trust, the only way to get them there is probate. So there is no easy answer to that question. Okay? Bob.
For a will, does it, when you die and the will is looked at everything, does it settle everything right then? Or can you push stuff out into the future? Like who gets what? Who gets a certain amount of your cash assets or whatever it is?
So, everybody hear Bob's question? He's basically asking me that if you use a will, does it settle everything right then, or can it push things out? Can those instructions go beyond just what happens immediately and say, hold on to it for this person for this long? The answer is it's just a set of instructions. And those instructions can do whatever you want them to do. So I will always counsel clients that if there's the potential for minor children to get anything, we need to craft a set of instructions that says, when and how and under what conditions they get to use it or get access to it, I will always counsel that minors in my book are minors until they're 30. Largely because I can kind of remember that if I would have gotten anything before I was 30, I would have blown it. So, that's typically the starting point. There are also plenty of circumstances, if we've got a special needs child or somebody who's going to need to be cared for, taken care of for the rest of their life or for a long time. We structure it accordingly. These days, I will tell you, because one of the bigger things parents worry about is not so much their kids being minors anymore, but their kids getting married, and the statistical likelihood that their first marriage is only going to be practice. So we'll structure it so that it's held in a trust for the child, and it's not controlled by that child, and oftentimes we'll structure those trusts that it's held there, they still have access to it, they can still use it, they can still get the benefits of it, but not control it until their retirement age, so that it protects them against what can happen in a divorce. So the instructions we build for how and when and under what circumstances beneficiaries get to use some of this are all over the place, and they should be built based upon what's truly going to accomplish what you want to accomplish in the best interest of the beneficiary.
So is that under a trust or under a will?
Well, if you're holding something in, subject to some instructions, and somebody's controlling it, that's always going to be a trust. That's the definition of a trust. But don't confuse that with living trust.
I had understood that inheritance in Washington was always separate property, not community property,
So the comment was that what we inherit in Washington is separate property, it's not community property. Technically, that's true. The law is pretty clear that what we receive by gift or inheritance comes to us as separate property. But I would also tell you that when I get an inheritance, I really don't want to have that conversation with my wife to say, I'm going to keep this in my separate account using my social security number because I'm going to worry a little bit that you might get half of it. I'm not going to have that conversation. Most people aren't going to have that conversation. The fact of the matter is it gets commingled.
It would be commingled if you use that money to make improvements in the home or something as community property.
Yeah.
Now, with property, some property is in the living trust and some property is not because the probate allowance has changed. Is that a problem?
Well, I mean, if you're using a living trust, then I would say use the living trust. Get the properties that are not in there so that you're avoiding probate.
The only reason I did a living trust was to avoid probate, but now that probate's not an issue in Washington, it didn't get transferred to the new.
Yeah, but you use the right tool to accomplish a good goal. There is no reason not to stay on that path. So take the assets that are not in the trust and get them retitled in there, and you're doing your family a huge favor. Okay?
You want to cover transfer on that, deeds and the like?
So I want to be respectful of the time, so I will talk for a minute about transfer on death. You probably know that you can go to the bank and ask them to put a beneficiary designation of sorts on your bank accounts. You can do that with your investment accounts. Your IRAs and your annuities all have beneficiary designations anyway, but transfer on death, TOD, or some use payable on death, POD, allows you to put a beneficiary designation on those assets. Using TOD has historically been a great way for us to avoid probate. And it's typically used in situations where we're trying to make sure that there's money readily available to whoever has to handle things when I die. Because of this misnomer that probate's going to seal everything up and you can't touch it for months, all that's wrong. TOD can be dangerous. What I've found over the years is that people who use TOD like it because they get the simplicity of it and they know that the money's all going to transfer automatically when they die, but they forget that maybe they've got that house that they also still own, maybe that cabin that's down in Packwood, and if all of the money has been transferred automatically out of the estate and there's no money left to pay property taxes, to pay insurance, to pay for maintenance or upkeep or improvements that might need to be made before things are sold, it's a problem. It's a big problem because I have 3 siblings and I can't even imagine, a couple of them, me having to go back and ask them to ante up to cover those costs. And my family's not atypical. So TOD is a great tool if you've got a bank account that you want to make sure is available to the one child that you have to handle things properly. It's not a great tool if there are multiple beneficiaries because the law says that whoever gets that TOD account, it belongs to them. They have nothing more than a moral obligation to share it with the others. That also causes trouble. So, great tool, like most of these tools, under the right circumstances.
You can do a deed also.
You can also do a deed, a transfer on death deed. Also not always the best idea. I've seen situations where people have this fairly elaborate set of instructions about how to best provide for their children when they die, and then they do trying to avoid probate, so they do a transfer on death deed to the one who's going to be the personal representative, and they do the TOD to that one person so that they've got all of the stuff readily available. Well, if they have it all and all they have is a moral obligation to share it, that's a problem. And frankly, legally, if it's all theirs and they decide to do the right thing and share it, they may have gift tax problems. So these shortcuts are like most shortcuts in that sometimes they're really great, but they can cause trouble. Okay?
What's the minimum level of trustees for a living trust? Do you have more than one other than yourself?
Well, who we appoint to these various responsibilities and whether we appoint more than one person or not is always a function of what is it we're trying to accomplish. What is it we're trying to do? It's not unusual. I mean, clearly with a living trust, it's fairly typical that a husband and wife are co-trustees. It's not unusual that if there's 2 kids, both of them get to be co-trustees when the time comes. So it totally depends on the circumstances and what we're really trying to accomplish.
So if it goes to that, for the main trustee dies, goes to the next trustee, then you've only got that person. So at that time, should they find another trustee?
Well, I think it's irresponsible of me, in my role writing those documents and talking them through with the client, to not have several layers of succession. So it's rare that you get to the bottom of that list, but it's always a good idea to have a list.
Because what happens if you run out of trustees?
Well, then the trust, if it's properly written, should have a mechanism for having the court appoint one. But we don't want to do that. These days, whether the court appoints is subject to whether the judge had what he wanted for breakfast that morning, or whether he had a fight at home the night before. So,
Can I clarify, when you talk about probate being better now, what was bad about probate was that when the state followed those instructions, they had a chance to take tax money or probate money. Is that,
No.
was that?
no, the state rarely gets any money because somebody died. Now, they get their share of taxes, certainly, but But even in a situation where we can't find, there's no will, and we can't identify who the nearest living relative might be, the state pushes us. There are processes that we have to go through that take months and months to go find who the nearest living relatives might be. The state almost prefers us to give it to charity than to let it go to the state. But there's unclaimed money, the website of the state that has that, some of that is there.
Is there a simple way to say what was bad about probate that got better? Because I thought it was the state getting their fingers on it.
Yeah. There is a simple way, because if you look at your wills, if your wills have been done in the last few years, they say, there's a phrase in there, probably towards the back, authorizing the personal representative to act with, there's powers that, let's see, how can I describe this? Okay, let me back up and I'll tell you what probate used to be. So if I died and my house is in probate and the grass is getting big enough, tall enough that the neighbors are complaining, and the personal representative wants to hire somebody to come in and cut the grass. They have to go to the lawyer has to fill out paperwork, it's a petition and a court order. They have to go appear before the judge and ask the judge to approve hiring the guy to cut the grass. And all of that is what bogged that system down. So the courts said, this is crazy. We should be allowed, if we do our job and we take a look at who's being appointed or nominated in the will to be the personal representative, and if we approve who that person is, because now they can sit up on their little place with their computer and they can see whether somebody's been convicted of a crime or what their background is in terms of what's in the public record. If they can approve who that person's going to be, then we should just give them the authority to carry out the instructions in the will and come back and tell us if there's a problem or tell us when it's finished. So now we are allowed to put in wills that the personal representative has what are called non-intervention powers. So as long as your will says that the personal representative has non-intervention powers, we don't have to go there. So it makes the process so much easier. And if we're not having to go to the attorney for all this little stuff, we don't have to pay them for that. They also changed one of the major rules that's still in place and what makes probate a nightmare in most states, which is there's law on the books in a lot of places that says the personal representative, or in many of those places they're still called the executor or executrix, must be paid a fee. So the personal representative and the attorney handling it must be paid their fee based on a percentage of the gross value of the estate. So that didn't used to be a big deal because the gross values of estates were much less. Now if you take somewhere between 2 and 8% of the gross value of an estate, it's a pretty big number. And if you take that one for the personal representative and one for the attorney, it's going to be a really big number. So Washington got rid of that requirement and said we want the process of doing the probate work to be competitive. So let lawyers compete. So what we have is we've still got some of the big firms, Bungle and Reed, and some of the big ones downtown Seattle who say, well, we've always done it based upon a percentage of the gross value of the estate. If you have to ask, you should go someplace else, so that's the way we charge it. That's what's reasonable to us. You have most lawyers who do it as an hourly thing. And then there are those of us who know what it should cost and what it should be in order to make it efficient. And so we can tell the client that here's what it will be to do this work, fixed fee. And so what's happened is that the costs of doing probate are much less. And it has forced all of us to be so much more efficient. That's how it's gotten better. Okay?
Right, and that's the money that the estate would save by having a living.
The estate would save whatever it's going to cost to do the probate. And obviously, back then, it cost a lot more to do the probate. So using the living trust to avoid that saved a lot more money. Today, what they save is a lot less.
So, is it better to have one or two executors?
So, again, it's going to totally depend on what you're trying to accomplish, who the people are, whether they can work together or not. I would never encourage that we have two if you're doing it just because you don't know which to appoint. And if they're not going to work together, we're creating a nightmare in an environment when our job is to try and find a way to simplify. So it totally depends on the people and the circumstances and what it is your goals are.
Okay, so let's say you assign someone and they don't follow what you want.
Then the beneficiary should sue them and have them removed, which is all doable. I see a question coming.
Yeah. I'm just wondering about, I don't understand totally the advantages of generational skipping. When is that used?
Okay, the question has to do with generation skipping, and it's a really good one to end on because it's going to totally boggle your mind. And I'm going to bore you with this because that's the only way to explain generation skipping. The estate tax is a tax that is assessed when things transfer, typically from one generation to the next. So when my parents left it to me, it got taxed. When I leave it to my daughter, it'll get taxed. When she leaves it to my grandchildren, it'll get taxed. Each transfer is taxed. What some of the very wealthy families in this country figured out, with the benefit of some good lawyering, is that if I leave mine in a trust for my grandchildren, but give my daughter access to it, I've accomplished everything I would have accomplished before, but I have skipped one of those taxable transfers. So Congress said, well, this is America. We can still give what we want to whoever we want to give it to. We don't want to get in the way of that. But when you do it to avoid taxes, we can come after you. So they created what's called the generation skipping transfer tax. And now if we leave anything to anybody who is more than one generation away from us, up or down, that generation skipping transfer is taxed at a flat 50%. Now, having said that used to be a big deal. But it is part of what we get the same exemptions that we get for estate taxes. So for federal law, we don't have generation skipping tax in Washington. And for federal law, a married couple still has $22 million that they can pass to grandkids. So it's kind of a non-issue now. It's again something you'll read about in Money Magazine or some other places, but it's a total non-issue right now.
Thank you.
Thank you very much, Gary.